Ordre du jour, orders of the day.
Government business, affaires du gouvernement. Projet de loi, troisième lecture, bills, third reading. Number 1, S13.
Stand.
Numéro 2, C-21.
Number 2, Bill C-21. Senator Yussuff.
Honourable Senators, I move that this bill be read a third time.
It is moved by the Honourable Senator Yussuff, seconded by the Honourable Senator Duncan, that the bill be read a third time. On debate, Senator Yussuff.
Honourable Senators, I rise, of course, to speak to Bill C-21 on Act to amend certain acts and to make certain consequential amendments for arms. Colleagues, 34 years ago today, Canada was traumatized by one of the largest mass shootings and the worst femicide in our history. At Montreal Polytechnique Engineering School, on December 6, 1989, a mass murderer entered the Polytechnique and murdered 14 women, wounding another 10 women and 4 men using an assault-type weapons. Why did he do it? He said simply, he was fighting feminism. I would ask colleagues to take a moment to remember those women who were needlessly murdered in cold blood and think about passing this bill might bring some peace to their families and the survivors of that horrendous day. The women who died that day include Genevieve Bourgon, Hélène Colgan, Nathalie Couteau, Barbara Tengville, Anne-Marie Edward, Maud Havernick, Jessie Lachenier, Cécile Laclaire, Anne-Marie Lemay, Sonia Pelletier, Michelle Richard, Annie Saint Arnot, Anissa Turcotte, and Barbara Coot-Vin. Senators, these weren't just women. They were members of family and loved ones. And they died needlessly because an individual did not see their place in society where they belong. They were studying to become engineers. He could not accept that. Of course, since that day, every day on December the 6th, we observe their deaths and try to do better. As a man, I have to say, if this is ever to end, men have to take responsibility for the violence that continued to occur to women, not only in this country but throughout the world. This is men's responsibility. Some of us wear these ribbons as a remembering and honoring of those women, but I know we have to do far more than that. Bill C-21, and their aspect to which I will speak to, addresses some of that. Senators, gun violence in this country takes many forms, from suicide to homicide, accidental death, femicide, that far too often manifest through domestic violence. All Canadians want safer communities. I think every senator in this place also, without fear of violence from guns. The problem has always been, how do we best achieve that goal? The legislation before us is not the sole way the government proposed to achieve this goal, but it is one part of the puzzle in doing so. Broadly speaking, C-21 will cement restrictions on handguns, create new harm reduction measures, increase penalties for those who break the law, and prevent new assault-type firearms from entering the Canadian market. I want to thank colleagues in the Senate Committee on National Security and Defence and Veteran Affairs who have worked very hard during the past 2 months in the study of this bill. I also want to thank the many witnesses who appeared during the study on both sides of the debate, including representatives from Indigenous communities and organizations, gun control advocates, gun right advocates, academics, researchers, law enforcement, women, and victims groups. Today I want to go over the main issue in the bill and then talk about some of the issues that were raised in the committee study of it. As I said in my second reading speech, debate about gun control is never easy. It is often emotionally charged and often leads to strong opinions on both sides. Because it's about the life and death, safe communities, and people's rights and privilege. I have tried to understand the debate on this bill through the lens of balancing the right with the privilege. I ask you, colleagues, to try to view this debate through that lens as well, because, senators, fundamentally, that is what this bill is about. Striking a fair balance between the rights of Canadians to safe communities and the privilege of Canadians to own certain types and models of guns for hunting, sport shooting, or collecting. Senators, I now want to take a few minutes to go over the key measures in the bill. However, I want to first start by clearly stating what this bill will not do, because there has been a lot of confusion both on the opposition in the other place and by some witnesses who appeared during our committee study over what effect it will have on the existing hunting guns and handguns. C-21 will not, I repeat, impact the classification of existing firearms, whether they are long guns or handguns, in the Canadian market. To be crystal clear, not one of the estimated 1.2 million handguns owned by approximately 300 legal license holders will be prohibited or confiscated. And not one of the estimated 12 million long guns owned by millions of legal license holders will be prohibited or confiscated because of this legislation. But colleagues, you don't have to take my word for it. My colleague, the leader of the opposition and critic of C-21, Senator Plett, has said the same. In the study of the bill on November 22nd, Senator Plett said, "This bill does not actually reduce legal firearms in circulation in Canada. The bill will certainly ban the purchase and sale of legal handguns, but it does not actually take any handguns out of circulation, at least not until someone dies, when their estate loses that handgun. Nothing prevents handgun owners or anyone else from owning or buying another firearm. The bill also confirms a ban on the so-called assault-type rifles, but doesn't reduce any other guns in circulation, including semi-automatic firearms. In fact, the government will actually pay gun owners to hand in their firearms that have been prohibited, and then, of course, permit those firearm owners to use that money to go out and simply buy other firearms if they choose to do so." Quote. Senators, if you are looking for one area of agreement between the sponsor, myself, and the critic of the bill, it is this. And I hope I have cleared up one of the major sources of confusion and contention about what is not in the bill. I would like to speak what is in it, beginning with handguns. As we know, handguns represent a serious and growing threat in our communities. Handguns, as most commonly used in firearms and homicide. The bill enshrined in legislation the national freeze on handguns, which took effect via regulation in October 2022. While current owners will be able to possess and use their handgun, the vast majority of individuals will no longer be able to buy, sell, or import handguns. The bill is careful, however, to create a path for individuals to develop in Olympic, Paralympic sports shooting disciplines. The minister, when he appeared at the committee, spoke about this exemption, and he submitted a letter just yesterday to our committee to address several concerns that were raised in our study, including the issue of exemption. Mr. Blanc said in his letter, I want to assure the committee that the consultation will take place to clearly establish the process for the elite sports shooter exemption. In my view, this exemption must apply to those who are currently representing Canada and those who are training and getting ready to one day hopefully represent Canada at the Olympics and Paralympic Games. There must be a pathway for the next generations. Colleague, the bill also includes new measures to combat firearms smuggling by increasing maximum penalties for gun trafficking from 10 to 14 years, setting up new authorities to combat firearms smuggling. The amendment also includes measures to address the growing threat to illegally manufactured firearms, the so-called ghost guns. Bill C-21 will create new offenses aimed at the use of 3D printing for the purpose of manufacturing and trafficking of firearms, classifying ghost gun and other illegal made firearms as prohibited. And it will require permits to purchase and import firearm parts to help prevent the illegal manufacturing and assembly of ghost guns. However, Senators, Bill C-21 includes new measures to address the harms associated with firearms in general. As I have noted in this place, suicide by firearms account for nearly 3/4 of all firearms-related deaths in Canada between 2000 and 2020, and victims of intimate partner violence are almost 5 times more likely to be killed if a firearm is present in the home. C-21 include amendments to strengthen measures to address the risk associated with firearms gender-based violence. Under C-21, individuals with a protection order against them or who have been convicted of certain offense relating to family violence will not be eligible for a firearms license. New red flag laws in the bill will allow courts to order temporary or immediate removal of firearms from individuals who may be in danger to themselves or anyone else. Measures to protect victims and applicants' identities are included in Bill C-21 to allow judges to conduct hearings and consider the evidence while also taking steps to protect personal safety. When a weapon prohibited order or a protection order is issued, this will be reported to authorities within 24 hours. Yellow flag laws will allow chief firearms officers to suspend an individual firearms license if the CFO receive information calling into question their license eligibility. Furthermore, the bill will help protect victims of violence and those at risk from self-harm by firearms. Firearm license will be automatically revoked if a protection order is issued. And if a chief firearms officer suspects that an individual has engaged in domestic or intimate partner violence or stalking, they must revoke their license within 24 hours. Also, if a person is undergoing a mental health crisis, they would be able to transport their firearm to another person or business for temporary safekeeping, helping to keep themselves or their loved ones safe. Bill C-21 address clear dangers that some firearm poses. Specifically, those firearms are better suited for the battlefield than our communities. Colleagues, we need to stand together and agree there is absolutely no place in our community for assault-style weapons. Firearms that fire deadly projectile as fast as the operator can pull the trigger poses a particular risk for mass shootings. Canadians have been clear about this point. Now, colleagues, the responsibility rests on our shoulders to put it into law. Senator, this bill will accomplish this by codifying a prospective technical definition of a prohibitive firearm in statute.
Senator Yussuff, I'm sorry, I have to interrupt. Honourable Senators.
Thank you, Madam Speaker. Yesterday, due to the adjournment, I was stopped in the middle of my speech. So to remind colleagues, I was talking about, of course, guns that I think most Canadians in this country would agree, guns that belong on the battlefield. should not be in the hands of Canadians, and the effort of the government, of course, to ensure that in this bill, those guns will be addressed. This will provide clarity for owners and manufacturers and prevent the entry into Canada market of new models that are particularly dangerous firearm once Bill C-21 comes into force. In addition to legislative measures, regulatory changes will require a firearm reference table record for all firearms, not just prohibited, restricted firearms, before entering the market in Canada. And that will help ensure that no firearms enter the country, Canada, market unaccounted for or incorrectly classified. It's also likely to point out, of course, that as we address the decades-old issue of firearms classification, the government has committed to re-establishing the Canadian Firearm Advisory Committee to independently review the classification of existing firearms. And I'll add, as the government contemplate the measures against assault-type firearm, it is working to strengthen the regulation on large-capacity magazines. That will require long gun magazines that be permanently altered so they can never hold more than 5 rounds. And regulation will ban the sale or transfer of magazines capable of holding more than the legal number of bullets. Colleagues, these are some of the main measures of C-21. I want to emphasize that the measures in this bill are not to be reviewed as the government's sole strategy to combat gun violence in the country. I would like now to speak to some of the other measures the government has and will undertake to combat firearms violence. I think it's important to appreciate that this is just one element of an overall larger strategy to address gun violence. Since 2016, the government have invested more than $1.3 billion in measures to address gun violence and keep guns out of the hands of gangs and criminals in our country. The government is supporting the development of new gun and gang violence prevention and intervention initiatives, which we have seen rolling out across the country over the past few years. In fact, the government is committed to $250 million to support the efforts of municipalities and Indigenous communities to build and deliver anti-gang programming. This is funding that builds on the almost $330 million provided to the province and territories under 2008 initiative to take action against gun and gang violence to combat gun and gang crimes. It is also add that the government announced an extension of the expansion of the program with a $390 million over 5 years through the Gun and Gang Violence Action Fund. That funding goes to the province and territories for a variety of initiatives, including support for law enforcement and prevention programs. In addition to providing funding to address the root cause of crime, the government knows that the cross-border smuggling of firearms also poses a threat to the safety and security of Canadians. Through Budget 2021, the government invested $656.1 million over a 5-year for CBSA to modernize our borders, including enhancing our ability to detect contraband and help protect the integrity of our borders infrastructure. All of this in addition to the legislation. Senators, I would like now to take a few minutes and moments to discuss some of the issues raised in our committee study of the bill. Our committee held 9 meetings over the past 2 months, hearing some 66 witnesses, including the minister and his officials, Indigenous organizations and governments, academics, researchers, selected firearms officers, representatives, and gun rights, and gun control advocacy groups and law enforcement agencies. I think it is fair to say the gun groups, by and large, do not support the legislation, while gun control groups and many law enforcement agencies do. I, like many witnesses who support this bill, note it is not a panacea, that there are many aspects of combating effectively and reducing gun violence in the country. However, all the advocates for gun control agreed that this bill is an important part of reducing gun violence, and all supported the bill passage without amendments. As Wendy Kuckler, co-founder of the Coalition for Gun Control, has said, no law is ever perfect, but Bill C-21 is a game changer for Canada and should be implemented as soon as possible. The law responds to most of the recommendation of the Mass Casualty Commission and demands of the Coalition for Gun Control, which, with more than 200 supporting organizations, has fought for stronger firearms laws for more than 30 years. We have heard from Anna Concliffe, who was the former Director of Research and Policy at the Mass Casualty Commission, who said that Bill C-21 and many of the recommendations made by the Commission in the Mass Casualty Report. We heard from women groups who spoke to the importance of red and yellow flag provision to protect women and help address the epidemic we face in intimate partner violence in this country. The National Association of Women in the Law was clear on the legislation. We support Bill C-21 and recommend its quick adaptation. While weaker in its original form, the bill now contains stronger measures to protect women who are victims of family and intimate partner violence. We also heard from law enforcement representatives, including Fiona Wilson, Deputy Chief Constable at the Vancouver Police Department. Deputy Chief Constable Wilson said generally of the bill, I think the bill strikes a good balance between respecting the rights and lawful gun owners and also give police more tools to address violence associated with guns in this country. She said more specifically on the ghost gun provisions. As I mentioned, there are lots in this bill that is important with respect to ghost guns. Of course, we are never going to be able to completely eliminate the ability of people to create privately manufactured firearms. But I think the provisions in this bill will go a long way to assist police with investigation, avenues and tools that we can use to try and investigate these types of situations, and hold offenders accountable when we do come across them, either through manufacturing ghost guns or in the possession of them. Senators, we heard some legitimate concerns about the bill in our study, and I want to address them. Specifically, the issue of chief firearms officers in the North, firearms instructors for restricted Canadian firearm safety course, and Indigenous consultation. Colleagues, several representatives from the North raised the issue that a chief firearm officer responsible for the North are not located in the North. The Northern Territories are the only jurisdiction where this is the case. Ensuring the chief firearms officer who have responsibility for the Northern Territory have a genuine understanding and appreciation of the North uniqueness by having to be located in the North is not only a legitimate concern, but I believe is a minimum requirement of these officials. I don't think anyone would disagree with this because it is an important issue of fairness, equity, and respect. Nathan Obed, president of ITK, who during a November 6, 2023 appearance before a committee explained it perhaps best when he said, the distance is more than geographic. It is also cultural and practical. We must ask whether such officials can adequately assess the understanding and unique circumstance and necessities of Innu hunters. I was very pleased to have Minister LeBlanc address this issue head-on in his letter to the committee, as I mentioned earlier, we received 2 days ago. The minister stated the following in his letter. Chief firearms officers, CFOs, in their terms, have an important role to play in the safety of lawful use of firearms in each province and territory throughout the country. In that regard, I've heard the views expressed by honourable senators as well as by witness regarding the presence of CFOs in the territories and the importance of place-based knowledge. I am committed to addressing this issue and will work with the premiers of each of the territories to do so. Minister shared with us his letter to the 3 territorial premiers, the state, pending the outcome of appropriate consultation with the urged government. I would like to appoint a resident CFO in your territory. I would value the opportunity to understand your views to ensure the unique circumstance and needs of the Northern Territories and its communities are met. I believe colleagues, the Minister is committed in good faith to agree with the Northern wishes when it comes to the issue of 3 firearms officers for the North that was raised in our study. Another issue raised was the concern related to the effect of handgun freeze will have on firearms instructors who provide restricted Canadian firearms safety course. It is a legitimate concern because we need there to be reliable number of instructors in the future to put on these courses. Whether that is to ensure sports shooters who want to participate in the Olympics or the Paralympics, handgun shooting events, have the ability to get their restricted license, or to ensure individuals who want to become guards in an armored car industry or even CBSA guards, the ability to get their restricted license. The Minister also addressed this concern in his letter to the committee by stating, I have heard your concerns regarding the firearms instructors and ensuring that they are able to access firearms they need for safety delivery training. As the operational model of the firearms instructor varies across the country, I have asked officials to work with relevant organizations to explore the option to support the delivery of this important service. Firearms instructors are vital to keeping our firearms owners and communities in Canada safe. Finally, frustrations were expressed by a number of stakeholders, in particular Indigenous organizations and governments, with the lack of meaningful consultation when Bill C-21 was being developed, in particular concerning the new technical definition of prohibited firearm related to assault-style weapons. I want to remind colleagues that the new definition was not included in the original bill and was only added in clause-by-clause consideration in the committee in the other place. I believe strongly that the government has a duty to consult Indigenous people if the legislation will affect them. This is why the government includes the non-derogation clause as an amendment to the bill in the other place. The minister letter of 2 days ago also addressed this concern regarding the need for meaningful consultation in the creation of regulation for this bill. He stated, while Bill C-21 will not abrogate or derogate from the rights of Indigenous people as affirmed in the Constitution, the Government of Canada must meaningfully consult with Indigenous people. Should proposed regulation have the potential to adversely impact potential or established treaty rights, the Government of Canada must satisfy its duty to consult and, where appropriate, accommodate those rights. Public Safety Canada will work collaboratively with the Indigenous partners through the development, management, and review of regulations. Honourable colleagues, Senators, in conclusion, this bill that is supported by gun control groups, women's organizations, victim rights groups, unequivocally, by a large number of law enforcement agencies across the country. And it reflects, I think, many of the recommendations of the report on the Mass Casualty Commission. I believe the freeze on handgun sales and transfer and a ban on military-style semi-automatic firearm is something the majority of Canadians want, I think, in this country. This has been reflecting in many opinion polls over the years, including most recent poll commissioned by our colleague Senator Dasko that found high support for key measures of this bill. The poll found that 85% of Canadians support or somewhat support prohibiting new assault-style firearms from entering the Canadian market. And on the controversial issue of handguns, 73% of Canadians support or somewhat support the freezing of the sale, purchase, transport, and importation of handguns. Colleague, the safety of our communities must be paramount, and any plan to combat gun violence must be comprehensive and well considered. This is not about taking firearms away from responsible owners, hunters, or sport shooters. It is about taking a common-sense, responsible approach to tackling violent crime and preventing senseless, tragic deaths. As I said at the start of my remarks, in view of this bill, through the lens of balancing the rights and safety of Canadians with the privilege of owning a gun to hunt, or sport, shoot, or collect, I believe, as did many of the witnesses who appear, including the Deputy Chief Constable Wilson, that the bill does indeed strike a proper balance. Senators, a tragic event 34 years ago started this country on a journey to ban assault-style weapons in our country, in our society. The bill before you is, in part, about honoring the memory of those 14 women and fighting for the legacy to complete that journey. It is also about fighting for a future that does not have to experience this tragedy ever again. Catherine Bourgon, the sister of Genevieve Bourgon, who died in the mass shooting, spoke to this last night at a tribute to victims of the Montreal massacre when she said the following: "It was a cold December night, a bit like tonight, and in the dusk of an early winter, they left us. They left us without warning, and they left us a legacy that can be summed up in 2 words: never again." Their loss cannot be in vain. Senator, although those women die very tragically, we have it in our power to give them meaning by passing this bill. I urge you to support the bill before you without amendment. Make that possible. Thank you so much.
You have a question? Senator Yussuff will take a question.
Question?
Good honor. Thank you.
Thank
Senator
you.
Duncan.
Thank you, and thank you for your breadth and depth in speaking today and speaking from the heart and speaking to a bill that has not been easy. I do have a question. I was happy to hear the minister has mitigated the CFO issue. We sat in committee and we heard about that repeatedly, so I was happy to hear that. It did make me think about something else today, though, and that is you mentioned in your speech that, this is part of the solution. This bill is part of the solution. There are other pieces at play and other things that we need to continue to work on as Canadians. So my question is, do you feel confident with this bill and the types of things that have been committed to being done with regulations and the work once this bill is passed? Do you feel confidence that those commitments and those promises to really refine the work of the bill will happen in the way that we need to?
Senator Yussuff.
First, thank you for the question. I call a piece of legislation. This is only one part. I think this legislation will bring forth new challenges, of course, not only for the government in regard to its implementation, but also our law enforcement officers who are on the front line, the province and the territory, work in a collaborative way to ensure the intent of the legislation and the outcome of the legislation actually will change the direction that we're seeing in this country in terms of gun violence. There are many things we will have to do, but it's equally important as the government will consult on the regulation that they hear some of the issues that was raised in committee and address them in a proper way that gives some meaningful understanding that some of the things that can be mitigated so that we don't see unintended consequence impact. And I'll start with one of the issues that come up in committee. Olympics, Paralympics, sports, people who need to have guns to participate in that is not impacted in the way that will reduce the number of people who want to get involved in the sports and ultimately compete for a country on the international level one day. The minister has given some assurance they're going to solve that, but I do believe, of course, we will have to continue to engage the government in that, and I know there are many folks who will do that. But equally, I do believe the intent of this bill is to try to tackle many challenges that we face with gun violence. We know far too illegal guns are coming into this country, and the government must work with law enforcement officers on the front line, how we can interdict those guns, as they are giving more money to CBSA to do that, but how do we also tackle the challenges that some of our youth who may get attracted to get into gun violence in their community, how do we deter them from doing that? That means the government have to continue to invest more money in our communities across the country, working with municipality, Indigenous organizations, both the province and the territory, so we can at least meet the broader objective that we don't see young kids getting into gun violence, but equally we're ensuring they don't get their hands on gun in the first place. That will continue the carnage we're seeing across the country, as we are seeing in our neighbours to the south.
Senator Deacon, supplementary? No.
No, thank you.
Senator Ravalia, you have a question?
Senator Yussuff, will you take a question?
By all means, thank you.
Senator Ravalia, please.
Thank you, Chair. Senator Yussuff, there's a significant concern being expressed given the fact that we have advances in digital technology of guns being printed by 3D measures and other such options, particularly in the underworld. To what extent has your bill studied that concern? Thank you.
Senator Yussuff.
Thank you, Senator, for your question. We had the good fortune to go to the RCMP gun vault for a visit, those of us that were participating in the study on the committee. And we saw firsthand how this technology is evolving and changing the manufacturing of ghost guns that are doing significant harm, and certainly from law enforcement are being used most frequently in crimes. They're hard to detect, they're easy to manufacture, and the technology proliferation are becoming much easier to access. And the cost of the technology is equally dropping in a tremendous way. The bill does address this head-on in regard to making it illegal for people to import the parts that will end up in these guns, and more importantly, giving the police on the front lines more tools to interdict that technology and, of course, help them address this concern. As you know, as this bill was introduced in the other place in the last year, we saw an expose at many coverage during the news how this technology is changing criminals' access to guns, that is no longer requiring having to get a license to go and get these guns. You can simply get them manufactured and, of course, be on the market. So I think the bill addressed this head-on by putting in restrictions in the importation of that technology, downloading that technology and using it, but equally giving the police and law enforcement officer tools now to charge and, of course, hold those accountable who might be involved in those kinds of trafficking of ghost guns, so we can ensure that this doesn't become a bigger problem for the country as you go forward. As you know, no measures in any piece of legislation will stop criminals from doing bad things. But we must do as much as we can to ensure the law enforcement officer have all the tools necessary so that they can do their job better, and of course raise the concerns with other Canadians that this technology is now broadly available. And we need to make sure, if you know about it, to ensure that you bring it to the attention of course, the law enforcement officers so they can interdict this technology and getting out of the hands of the criminals in our country.
And then I have Senator Omidvar. Senator McPhedran.
Thank you, Madam Speaker. Will you take a question, please?
With honor.
Thank you. Dr. Pamela Palmenter, the Mi'kmaq legal scholar and lawyer, presented to the committee and indicated her support for this bill. She also noted that the bill should provide for the way to craft regulations that acknowledge and respect and integrate inherent and treaty rights for Indigenous peoples in this country, and that there should be a process that allows full, equal participation by the nations of First Nations, Inuit, and Métis peoples. Does the bill do this? Will the bill do this?
Senator Yussuff.
Thank you very kindly for the question. I think this is an issue we were, of course, was addressed to the committee during our hearing, and she, of course, spoke to us directly. As you know, and I said earlier in my remarks, when this bill first started out in the other place, it did not include Section 35 of the Constitution in terms of protecting Indigenous peoples' a firm right in the Constitution. A subsequent amendment was made in the other place before the bill arrived in the Senate. I think it confirms that. Now it's in the bill. It's a fundamental part. And more importantly, of course, the minister took the time to write to us that in the context of developing regulation, he will ensure that his official, of course, will properly consult with any First nations in which any part of their regulation will impact. If it's going to impact them, they need to be consulted. That's what the regulation, in Section 35 call for, and the government is confirming that's what they intend to do once they start developing regulation in regard to Bill C-21.
Senator Omidvar, you have a question.
Thank you. Will the Senator take a question?
Yes.
Thank you, Senator Yussuff, for your work on this bill. It's an important bill, and there are lots of details in it. And I'm sure I missed one part of your speech when you talked about the re-establishment of the Canadian Firearms Advisory Committee, which will independently review classification of firearms. So my question is, in case I missed it, and in case you can help me, what is the timeline for the re-establishment of this committee, and who will it be made up of?
Senator Yussuff.
Thank you for your question. The government did confirm that they will re-establish the committee once the bill has get royal assent. And of course, I think that should include a variety of people, of course, who have knowledge. I think CFOs from across the country who are on the front line, of course, giving guidance to the enforcement of our gun legislation, and of course, who are there to deal with some of the challenges we face in regard to enforcement issues should be on the committee. I think First Nation representatives should be on the committee. I think gun advocates should be on the committee because they have concerns, and that they should also inform the committee of its work. And I also think advocates for gun control should be on the committee. So I think it should be a balance representing the country that would be, is my hope and my understanding that will be on the committee. Of course, the final word rests with the minister and the government in regard to the appointment of those people. And we've been assured as soon as the bill does get royal assent, the government will move to establish such a committee to ensure that work can begin as soon as possible.
Senator Sorensen.
Speaker, Senator Yussuff, there was an observation that was endorsed during committee with respect to family heirloom handguns and the transfers of those. And it seemed that the committee understood that Bill C-21 would create additional rules in relation to those handguns, and with some exceptions, new registration certificates for handguns would not be issued. And it was going to make it very difficult, will make it very difficult to hand those heirlooms down to family members. And I see what the recommendation is, or the observation is. If you could just maybe expand a little bit on what the observation encourages the government to do. And I was brought up in a home with, my father had one of the finest antique gun collections in all of Canada. He had nothing pre-World War, anything post-World War I. And I've had some of his friends contact me saying, you know, what are we going to do with these heirlooms, also with extensive value to those heirlooms?
Senator Yussuff.
Thank you kindly for the question. That observation did come from me.
My dad thanks you.
And it was on reflecting, hearing some of the evidence, both understanding what was said in the other place, and talking, of course, to some of the CFOs who are on the front line dealing with some of these issues. I think that from my perspective, the government need to find a way. And I would describe it this way. Sort of a car buff goes to my tradition. If I had a 1952 Chevy and I chose to leave it to my daughter, she may never drive it, but she may want to own it because her dad have this as a possession. I think it's fair and reasonable, even though the law may change on pollution, is for her to make that decision. I believe the same respect and courtesy should be given to families who have had heirlooms in a historical context that wish to leave it to their family. They need to find a way to make sure this is addressed in a real way. And I think the government need to deal with that. It was not properly addressed in the bill. But I do believe it's something the government should take the recommendation.
Senator Yussuff, sorry, the time for debate has expired. Senator Boisvenu.
Merci beaucoup, Madame la
Senator Boisvenu. Thank you very much, Madam Speaker. Honorable Senators, dear colleagues, I rise today to speak on Bill C-21, an act to amend certain acts and to make certain consequential amendments, firearms. In my remarks, I will address one of the most glaring shortcomings of the bill in its current form, which is at the root of all the problems with Bill C-21. This shortcoming is due to the fact that the government held virtually no consultations when drafting this legislation. Why is this important? First, because the government has stated that it had consulted almost everyone before drafting this bill. The minister confirmed for us that consultation had been held, but I do not agree. Secondly, because knowing that there were no consultations during the drafting of Bill C-21, we can assume that consultations during the upcoming regulatory process will be equally non-existent. In my opinion, this is a problem that we must resolve in the current bill. I would like to begin by reiterating what the government has actually said about consultations on Bill C-21. As Senator Plett and others have recalled, when the minister appeared before the Senate Committee on National Security and Defense on October 23rd, he said, and I quote, "We engaged with First Nations, Inuit, and Métis organizations, with rural and northern communities, victims groups, the firearms community, and sports shooters across Canada to hear their views and to ensure that we respect their traditions and way of life. These consultations have helped define the way forward," end of quote. Colleagues, that is exactly what the minister said in his testimony. But when the senators at the National Defense Committee began to question other witnesses on whether or not they had been consulted on C-21, we saw that, and we asked if it was true consultation or just an information session. They answered us one after another. Dr. Terry Bryan from Saskatchewan said there was absolutely no consultation. Robert Frigberg, another witness, said no, there was no consultation. The regional British Columbia Regional Chief for the Assembly of First Nations, Terry T.G., and I quote, said at best they were minimal or even inexistent. Will Davis from the Inuit Tapirit Kanatami said, to say it simply, there were no consultations. The minister communicated with us and we made a request, but that request was never answered. There were no consultations, end of quote. Another witness said, the ITK, which is the Canadian Inuit organization, said that ITK was not fully consulted regarding this bill, nor about the impacts that it could potentially have. Jessica Lazar from the Mohawk Kanawaki Council told us we had one single meeting and it was not adequate consultation. I do not consider us having been consulted. Sandra Honor, president of the Federal Advisory Board for her community, said
the committee that did not invite the Shooting Federation of Canada to participate, and there was no response to the various letters we wrote to the minister. End of quote. Marcel Wilson, founder and speaker of the Toronto's One by One movement, when asked if anyone in the community had been consulted about the bill, responded, and I quote him, "I have to say no, absolutely no one." Gilbert White, Saskatchewan Wildlife Federation, and I quote him, "The Saskatchewan Wildlife Federation was not consulted." Doug Chiasson, Executive Director of the Fur Institute of Canada, said that the Institute was not consulted. Edward Leonard Bush, Executive Director of the First Nations Chiefs of Police Association, and I quote him, "We had discussions with the previous minister, Mr. Mendencito. I wouldn't say it was a thorough consultation." Didier Desramon, Executive Director of the Association des Directeurs de Police du Québec, Québec's Police Chiefs Association, he said, quote, "We had a discussion with the minister's office and the minister, but it was more of a presentation than a consultation." End of quote. Colleagues, here are words that we kept hearing from witnesses. We were informed, but not consulted. Colleagues, given this mountain of testimony, how is it possible for a minister of the Crown to come before the committee and claim, as he did, and I quote him once again, "We have engaged with First Nations, Inuit, Métis organizations, rural and northern communities, victims groups, the firearms community, sportsmen and sportswomen across Canada to hear their views and ensure that we respect their traditions and way of life. These consultations have helped us define the way forward." Allow me to say, colleagues, I think we've seen better consultations in the past. Dare I ask, colleagues, does the truth no longer mean anything to the current government? Is this government so confused with its own bill that it did a roller coaster ride? It's on such a roller coaster ride that consultation and information are now the same to them? I strongly urge the current government to get a dictionary in which it will find a clear definition of the two words and will discover that there has been no serious consultation on this bill. The lack of consultation with Indigenous organizations and communities is particularly outrageous, given the government's extremely clear commitment in the UN Declaration on the Rights of Indigenous People to fully consult, and I repeat, fully consult Indigenous peoples on all matters affecting them. So what does this consultation record mean? It's the wrong word, really. We should say information record. So, in my opinion, it means that we have a very serious issue with the implementation of this bill, and we must correct it. Indeed, the minister made it clear in his appearance before our committee that he now plans to work through regulations. Regulations are generally developed through an even more closed process than bills. And I know something about it. Having been at the senior levels of the Quebec government for 4 years, we had a bill, it was adopted, we gave it to the ministers, and then officials, public servants, would develop the regulations, often without consulting the people affected. A number of witnesses who appeared before the committee expressed deep concern that they will now be ignored in the ongoing regulatory process, as ignored in the ongoing regulatory process as they were in the drafting of the legislation itself. When Terry Teague, Regional Chief of the Assembly of First Nations for British Columbia, appeared before the Senate committee on November 6th, he expressed concern about the significant regulatory leeway provided by Bill C-21. He asked our committee to amend the bill. He asked our committee to amend the bill to create an oversight mechanism that would guarantee consultation before any infringement of First Nations hunting and subsistence rights. Colleagues, as we have seen, the particular situation of Indigenous peoples was a major concern of Inuit witnesses who appeared before the Senate committee. In particular, all witnesses expressed grave concerns about the ongoing regulatory process. My amendment proposes to address this issue in the best possible way and in the most positive possible way. It makes it mandatory to consult on any regulations likely to affect the rights of one or more Indigenous groups, communities, or peoples, as recognized and affirmed by Section 35 of the Constitution Act 1982. It also requires the government to take into account the unique circumstances and needs of these Indigenous groups, communities, and peoples, and to prepare a report describing the consultations undertaken. My amendment simply enforces what the government itself committed to do and imposes it on the government. They committed to this in the United Nations Declaration on the Rights of Indigenous Peoples. I believe this is a minimal but necessary step, and I ask you to send at least one very clear message to the government by adopting this amendment. I therefore move, and I thank you in advance for your support for this amendment, on which we will soon be voting. And I ask you to give the Indigenous groups, communities, and peoples' rights your support. Honourable Senators, I move that Bill C-21 be not now read a third time, but that it be amended on page 51 by adding the following after line 30. 45.1. The Act is amended by adding the following after Section 118. 118.1 bracket 1. If a proposed regulation may affect one or more Indigenous groups, communities, or people's rights recognized and affirmed by Section 35 of the Constitution Act 1982, the federal minister must, before the proposed regulation is laid before each House of Parliament, under subsection 118 bracket 1, consult with a variety of Indigenous governing bodies and a variety of Indigenous organizations in order to take into account the unique circumstances and needs of those Indigenous groups, communities, and peoples. 2. If subsection 1 applies, the federal minister must include with the proposed regulation laid before each House of Parliament pursuant to subsection 118.1 a report describing the consultations undertaken. The following definitions apply in this section. Indigenous governing body means a council, government, or other entity that is authorized to act on behalf of an Indigenous group, community, or people that holds rights recognized and affirmed by Section 35 of the Constitution Act of 1982. Corps dirigeant autochtone. Indigenous organization means an Indigenous entity that represents the interests of an Indigenous group and its members. Organisme autochtone. Thank you. On debate. It is moved. In amendment, it was moved by the Honourable Senator Boisvenu, seconded by the Honourable Senator Seidman, that Bill C-21 be not now read a third time, but that it be amended on page 51 by adding the following after line 30. May I dispense? 45 by the following, by adding the following after line 30. 45.1. The Act is amended by adding the following after Section 118.
1. If a proposed regulation may affect one or more Indigenous groups, communities, or people's rights recognized and affirmed by Section 35 of the Constitution Act 1982, the federal minister must, before the proposed regulation is laid before each House of Parliament under subsection 118.1, consult with a variety of Indigenous governing bodies and a variety of Indigenous organizations in order to take into account the unique circumstances and needs of those Indigenous groups, communities, and peoples. 2. If subsection 1 applies, the federal minister must include with the proposed regulation laid before each House of Parliament pursuant to subsection 118.1, a report describing the consultations undertaken. 3, the following definitions apply in this section. Indigenous governing body means a council, government, or other entity that is authorized to act on behalf of an Indigenous group, community, or people that holds rights recognized and affirmed by Section 35 of the Constitution Act 1982, Corps dirigeant autochtone. Indigenous organization means an Indigenous entity that represents the interests of an Indigenous group and its members, organisme autochtone. On debate, Senator Yussuff.
Thank you, Madam Speaker. First, let me thank my colleague and friend, Senator Boisvenu, for his intervention and thank him for his work on the committee in regard to Bill C-21. In regard to this amendment, you wouldn't be surprised, colleagues, that I would ask you not to accept the amendment. Well, I like Indigenous people enormously. I'm glad to see my friends have newfound respect for Indigenous people. I think the reality is that this amendment was tabled at the committee. The committee rejected the amendment. But I want to speak specifically in regard to the amendment. I think I include that in my speech earlier, but I will restate for colleagues before we have an opportunity to vote on the amendment. While Bill C-21 will not abrogate or derogate from the rights of Indigenous people as affirmed in the Constitution, the Government of Canada must meaningfully consult with Indigenous people. Should proposed regulation have the potential to adversely impact potential or established treaty rights, the Government of Canada must satisfy its duty to consult and, where appropriate, accommodate those rights. Public Safety Canada will work collaboratively with the Indigenous partners through the development and management and review of regulation. This is the assurance we have from the Minister. Section 35 is enshrined in the bill to give it meaning, to ensure if the government doesn't do its job, somebody can go before the courts and take the government to task. But the government recognized the importance of consulting, but it's also recognized the fact that Indigenous people have certain rights in this country that we must oblige ourselves to respecting in that regard. Colleagues, I can go on at length, but I spoke, I think, very well. We did, of course, convey as a committee in the observation in regards to the bill. And the Minister, of course, wrote to us to address this exact issue in the context of consultation going forward in regard to any regulation that might adversely impact Aboriginal people in regard to, of course, the implementation of this bill. As we know, regulations within the Crown is always something that they do. They have an obligation to publish those regulations, get comments and respond to it. But I think Section 35 obligates them to go even farther than that, and that's enshrined in the bill. So, honourable colleagues, I would ask you to reject the amendment because it was, of course, dismissed at committee, but equally thank you, of course, and recognize what's also been enshrined in the legislation under C-21.
Senator Dupuis, and then
Senator Dupuis.
Dean and Senator Patterson Nunavut. Senatrice Dupuis.
Merci.
Senator Dupuis. Thank you, Madam Speaker. The amendment before us concerns rights that are recognized.
Senator Plett, you had a question? Yes. I'm sorry. Then I'll get back to you, Senator. And Senator Patterson, did you have a question? Yes. Okay, but first I'll go to Senator Plett, who has a question, and then I'll go to you, Senator Patterson. Senator Plett.
Well, just one very short question, Senator Yussuff, if you would. You used one of the reasons for us not doing this here is because it was defeated at committee. And that's probably a reasonable argument. How would you feel about C-234, where we defeated amendments at committee and then you voted for them right here in this chamber?
Senator Yussuff.
If I may, in response, Senator Plett, I prefer to talk about C-21, which is before us right now.
So you're not answering the question?
Well, I'm answering. If you want me to speak about C-21, I'll be happy to speak about C-21.
So you're
I do believe my friend have every right in tabling the amendment that's before us, and I gave a response why we should reject the amendment. I'm not suggesting he doesn't have a right to table the amendment, so let's be very clear. He has a right to table the amendment. I accept that, and so does the Senate. But equally, I believe the issue that he's raising in regard to the amendment is adequately addressed in the legislation in C-21.
Senator Patterson, Nunavut.
Thank you, Madam Speaker, and thank you for your sponsorship of this bill, Senator. My question is really simple. You have just said that the minister will work collaboratively with Indigenous groups in the development of regulations. That is necessary. The witnesses were very clear that they have unique circumstances and needs that should be addressed. So if the minister is going to work collaboratively with Indigenous organizations in the development of regulations, why would you oppose an amendment that is proposing to do precisely that? What's wrong with an amendment that reinforces the commitment you've already said the minister will undertake in speaking to the bill?
Senator Yussuff.
Thank you, Madam Chair, and thank you for the question. As I said, Section 35 is enshrined in the legislation. It obligates the government to do so. The minister simply reinforce what's already in the bill, that they have an obligation and a legal responsibility to consult with Aboriginal people in regard to development of regulation that may adversely or not impact them in this regard. And he's just reinforcing, of course, what's already in the legislation. So I think the amendments before us is redundant and unnecessary.
Senator Yussuff, your time, Senator Yussuff, your time for debate has expired. I have, pardon me. So on debate, that was a question. On debate, Senatrice Dupuis.
Senator Dupuis. Thank you, Madam Speaker.
Senator Yussuff wasn't on debate. Senator Yussuff was answering a question on the amendment. I don't think he had 15 minutes on the amendment. I'm sorry. If that's what he had, Madam Chair, I'll stand down on it. But I think there may be some confusion there.
Yeah, Senator Plett, let me check with the table officers because my clock here was not working, so please, I'll just check 1 second. So correction, I'm sorry, he still has 10 minutes. Therefore, I believe Senator Patterson, you had a supplementary question.
If I may, Madam Speaker.
And then I will go to the Senator Boisvenu. Thank you.
Thank you, Madam Speaker. Senator Yussuff, you've told us basically, trust the government. We have an obligation to consult because of the reference to Section 35 in the bill. So don't worry, it's going to happen. The minister said it was going to happen. But we've also heard clear evidence that there was no consultation with the Inuit in the development of the bill. So why should we trust the minister to consult on the development of regulations when there was no consultation on the all-important development of a bill that affects Inuit profoundly as hunters, as people who have to survive on the land, as people who have to defend themselves from predators like polar bears who have killed Inuit in my region. Why should we trust the minister to consult on regs when there was no consultation on a bill which profoundly affects Inuit before the chamber today?
Senator Yussuff.
Thank you, Madam Chair, and thank you again for a supplementary question. I'm not asking you to trust the minister. The legislation basically enshrine the rights of First Nation people to be consulted under Section 35. That is fundamentally what's in the legislation. And should the minister or the government not follow that direction, any organization can take a minister to court not meeting his obligation under Section 35 of the legislation. It is clear and simple. If it was Section 35 was not enshrined in this bill, we have every reason to fear the government will not respect that section of the Constitution. What is in the bill is enshrined in the bill. When the bill was first developed, Section 35 was not part of the bill. The government recognized it was a flaw and subsequently amended the bill to include Section 35 to ensure they were assuring themselves, but more importantly, this is what the Constitution is about. Do we have to write it over? It's now written in to give clarity and certainty. Does that mean a government may not violate that at some point? It's quite possible. But at least there are legal remedies should the government choose not to do so at the end of the day. That's what a court of law is for. There's lots of laws we pass in this place. Are we always assured that the government is going to follow the law as is stated based on the adoption we make in this chamber? But we have remedy if that doesn't happen. That's what Section 35 speaks to. And I'm glad, of course, when the bill was discussed in the other place, Section 35 was added to the bill to make certain that First Nation rights are going to be protected in the context of this legislation becoming law in this country.
Senator Boisvenu.
Senator Boisvenu, would the senator take a question?
Senator Yussuff.
Senator Yussuff,
Senator Yussuff, I have a great deal of respect for you, and I would even say I feel friendship towards you. But when what we're seeing now in terms of respecting the law, let's talk about the Charter of Victims' Rights. This government did not respect the victims' rights. The Constitution obliges the government in Section 45 to consult Indigenous peoples and groups, and they're telling us, those groups are telling us that they were not consulted. So even the Charter of Rights and Freedoms has not been respected by this government. This government brags about wanting to reconcile with Indigenous peoples, and yet they're not complying with the Indigenous Charter, with the United Nations Charter on Indigenous Peoples. So I'm just wondering what planet you live on. Senator Yussuff.
Again, Madam Speaker, thank you, and thank my colleague for the question. I live on the same planet he lives on, but I don't live in a perfect world, and nor does he. The reality is, of course, can the government do better? Can the government, of course, ensure it's going to meet its legal responsibility as stated in the Constitution? I believe so. I would like to believe that the minister's letter was a serious attempt to ensure and recognize some of the points we made in the observation in regard to the bill. And then the witnesses who came before the committee to testify. Can the government do better? Yes, the government can do better. And we urge them to do better as part of our recommendation. But in the context of First Nation right in regard to Bill C-21, the government is enshrined Section 35 of the Constitution to give certainty and recognition that there's certain things that is obligated to do as a result of the Constitution of the country. Is it possible that some part of the administration may not follow that? It's quite possible. We're in the place of human beings. But at least there's legal remedy should they choose not to do so. It is my hope in regard to this bill, which is a very challenging bill trying to regulate guns in this country, the government would recognize fundamentally the relationship to First Nation people and their right to hunt for sustenance in this country. It is fundamentally recognized, as the minister states in his letter to us, but equally as it was told to us by witnesses who came before the committee. I'm honored to have been part of the process to hear that, but also to reinforce to the government, as we did in our observation, for the government to ensure that it does a better job in consulting with all groups that is necessary in regard to the regulation process that will undertake once the bill becomes law in the country.
Senator Patterson, you had a supplementary?
If I may, Madam Speaker, yes, thank you. Senator Yussuff, you've talked about the importance of the reference to Section 35 in the bill and the need to follow the law. Would you agree that without an amendment like this, which requires the minister to undertake consultations if their rights are affected, their subsistence hunting rights are impacted by the implementation of this bill, what Inuit will be left with is a requirement to hire lawyers and go to court and incur expenses to enforce consultation with them that this amendment would require without having to go through litigation and hire lawyers and pursue their rights in a court of law as you described.
Senator Yussuff.
Thank you, Madam Speaker. Again, I want to thank my colleague for the question. It is my hope that Section 35 will be respected in the broadest possible manner in regard to the obligation of the federal government. These are fundamental rights of the citizens of our country. And the reason it's enshrined in the bill is to ensure that those who are responsible for the implementation of this legislation will understand this is a critical and integral part of how we respect. It's been a refreshing change to see this country and senators, including our colleagues in the other place, recognize the importance of Indigenous people's right in this country. I believe this has been long overdue. It is my hope that no one would have to go to court from Indigenous community to get remedy because the government has not done its obligation in terms of consulting in regard to regulation that may arrive as a result of the implementation of this bill.
Senator Quinn.
Thank you, Speaker. Would you take another question, Senator? I'm just wondering, first off, I want to say that I really appreciate you bringing the bill forward. I support the bill. But on this question of this amendment, I'm a little bit confused in a way, in that, as Senator Patterson said, that the government has had many court cases that it's had to deal with because of oversights in consultations with First Nations. And while Section 35 is there and there is a duty to consult, that often is challenged in the courts and often results in lengthy court cases, multi-year court cases at great expense to everybody. This legislation is so fundamental in terms of Aboriginal rights, as you said, for sustenance, hunting, and things of that nature, that wouldn't it be an advantage to make sure that as officials look at the regulations that there's not a oops moment and that they are absolutely certain and sure that they must consult First Nations, rather than count that, yes, Section 35 is there, but that will lead to court cases that could go on for long periods of time.
Yussuff.
Thank you again for the question. Thank you, Madam Speaker. I think the Minister, again, as a result of our work on the committee, which was very lengthy in regard to hearing witnesses, tried to address that to the committee in totality. He says, should proposed regulation have the potential to adversely impact potential or established treaty rights, the Government of Canada must satisfy its duty to consult and, where appropriate, accommodate those rights, Public Safety Canada will work collaboratively with Indigenous partners throughout the development and management and review of regulations. I think this just assured us, again, the Minister is very conscious and aware
Senator Yussuff. Senator Yussuff, your time for debate has expired. There are a few other senators that want to ask questions. Are you asking for 5 more minutes?
Madam Speaker, I'm in your hands. I'm not asking for anything. But if colleagues want to offer 5 more minutes, I will gladly take it.
Is leave granted, senators? I hear a no. Senatrice Dupuis.
Senator Dupuis. Thank you, Madam Speaker. The draft amendment before us, in my opinion, would create a situation where we would be limiting the government's obligations regarding consultation. It's supposed to consult Indigenous leaders and organizations and take into account their needs. I think it's important to understand that the rights that are affirmed and recognized in Section 35 obligates the government to do more than consultation. It obligates the government to amend legislation, whether it's acts or regulations. And beyond that, the act that we adopted to implement the United Nations Declaration on the Rights of Indigenous Peoples obligates the Crown to do more than just consult, because it also has to develop projects in collaboration, and that also applies to activities and regulations. So in our jurisdiction, if we know that there are rights that are recognized and create obligations for the Crown, I would then imagine that we as legislators would not want to limit those rights by limiting, as it is proposed here, to consult Indigenous peoples on the basis of their constitutional rights to take their situation into consideration. Therefore, I will be unable to support this amendment.
I see 2 senators rising for questions, so I have Senator Lankin and then Senator Prosper. Senatrice Dupuis, vous acceptez prendre une question?
Senator Dupuis, would you agree to answer a question? Yes, certainly.
Senator Lankin.
Merci, Madame President.
Thank you, Madam Speaker. Pardon me, I must ask my question in English.
Efficient to do all of this in French. I agree with what you just said about the fact that Section 35 requires more of the government than this particular amendment being put forward. But I have another very significant concern, and I hope you, in particular because of your legal background, may be able to either assuage my concerns or agree that this is a concern. The amendment that comes forward, and we've heard over and over and over, and I'm not sure why people are insisting on another amendment that accomplishes the same thing and even less, limited. It is already in the legislation, and we're looking to put another version of that in the legislation. My concern is, if anything does end up before the courts will be obligated to look at both of the clauses and understand whether this clause from the amendment, in fact, narrows the other reference to Section 35. So I think we are all agreeing that we want this to happen, and we want this government or a future government, and I wish that the former Harper government and the former years of the Trudeau government had taken more care with respect to consultation. But do you share the concern that having 2 competing clauses that speak to the same issue necessitates those in the judicial field to weigh what the importance is and to understand and second-guess why this Senate put forward 2 similar amendments that potentially are not accomplishing the same thing at the end as you made in point you made in your speech.
Sénatrice Dupuis.
Senator Dupuis. Thank you, Senator Lankin. I would like to clarify that you have the constitutional right to speak in English in the Senate chamber, and I have that same right to do so in French. And I think that that is great. So I hope that interpretation is allowing you to enjoy those rights, which we both have. I appreciate that. What I'm trying to say here is that we have often heard about the dialogue between the legislator and the courts. The legislators create the laws, which are interpreted by the courts. Sometimes the courts cancel them, saying that we've gone out of our jurisdiction, etc. The interpretation that has been given to date goes further than just an obligation to consult. It also is an obligation to amend legislation and projects. So the risk with what we're debating today is that we could send the message to the courts that, in fact, their interpretation might have been going too far all along, and that actually it's not necessary to obligate the Crown to be able to amend bills. And so then the courts would backpedal. I'm not sure if that answers your questions. That's what I can tell you.
Senator Prosper, I understand that you're rising on debate, so I will come back to you after Senator Dean. Senator Dean, on debate.
Thank you. Thanks, colleagues. And I'm standing just to add some thoughts to those that we've heard over the last 10 or 15 minutes. I start by thanking Senator Boisvenu for his statement and his proposed amendment. But I also look to my colleagues, including Senator Lankin and artfully Senator Dupuis, who have put that amendment into context. And that, to me, seems pretty definitive and determinative. So thank you for that, Senator Dupuis. Indigenous consultation and engagement, we all agree, is hugely important. I'm sure we all agree as well, those of us who have engaged in this practice or attempted to, will know that it is an enormously complex and challenging and worthwhile and constitutionally required practice. We have an extensive range, as most of you know, or all of you know, of governance arrangements across this country that varies by province and geographic area and by the nature of the makeup of an extensive and unique fabric of the governance arrangements that are practiced by our Indigenous colleagues, our Indigenous brothers and sisters. That complexity takes nothing away from the constitutional right to consult. In fact, I think makes it more important. But I think it's fair to acknowledge that our success in consultations and engagement with Indigenous people has had mixed success, to put a positive blush on it. It's a work in progress. It's a work in process. And absolutely, we haven't got it right. And an amendment to this bill isn't going to get it right. The Constitution is clear in its requirements. We all know what is required of government. But let me say this. Success has been mixed, but I don't recall any other government at the federal or provincial level having put as much time and effort and money and resources into consultations with Indigenous people as the current government has. It's fallen short, but it's done a hell of a good job. it's tried hard, it's worked hard, to actually the point of being criticised in some quarters, irresponsibly, that perhaps it's going too far. Of course it's not going too far. It hasn't gone far enough. I don't need to remind you about the national inquiry into murder and missing Indigenous women and girls, dramatically shifting the yardsticks for the better in terms of cleaning up water on Indigenous reserves that others have failed to do for decades, for responding to calls for recognition of the UN Declaration of the Rights of Indigenous Peoples, which was a hard battle in this place, which was a hard battle, wasn't it? And we all know whose side people were on in here. That's all I'll say. I have never seen the demands that have been placed and expectations that have been placed in federal departments at all levels right across this country to take Indigenous consultation and engagement seriously. That has been there, it's on the record, and you talk to anybody in a federal department and you are going to hear that. We listened in our committee to Indigenous colleagues. And I'd like to think that our Indigenous colleagues and brothers and sisters were heard in the committee, and I think they were. There was mixed success in the consultations on this bill, and the government has amended the legislation as a result of that in response to concerns and toughened it up. And we've heard Senator Dupuis a very eloquent and important and I think decisive response to the amendment before us. Colleagues, that's all I want to say. I am nothing but grateful for the ability that I had to come to this country, to see this country struggle with its issues, to be part of that struggle with its issues and other struggles in here. This is an ongoing process. We've got more work to do. We've got a government that takes this seriously. We've got a government that did its best to hear from as many people as possible and reflect their concern in this legislation. I do not think that we need this amendment. Thank you very much.
Senator LaBoucane-Benson, you have a question?
Would the Honourable Senator take a question?
Senator Dean. Senator LaBoucane-Benson.
Thank you, Speaker. I want to speak specifically to, in this proposed amendment, Section 45.1, bracket 2, which talks about reporting to each House of Parliament. And as you're the chair of SecD, and you heard all of the testimony and are very familiar with the bill, in general, there's a public process of consultation and engagement for all regulations, but the Firearms Act in particular already goes further than most other laws. Section 118 of the Firearms Act actually requires that firearms regulations be tabled before both Houses of Parliament within 30 days, with the SecD committee having the option to study the regulations and report back. So, Senator Dean, do you agree that this existing process in the firearms bill already gives senators an opportunity to evaluate the quality of the government's consultations?
Senator Dean.
I absolutely do, and I thank Senator LaBoucane-Benson for reminding all of this, of the rubric of the bill and the efforts that have been made to build a consultation and engagement into it. Thank you.
Senator Prosper, on debate on the amendment.
Thank you, Madam Speaker. I just want to add, and I appreciate my colleagues in this chamber for offering their perspectives on the nature of this amendment being proposed here. A lot has been said about the existing constitutional obligations upon the Crown to consult with Indigenous peoples. And following Senator Dean's comments, one can say there has been certainly positive steps being taken both from a legislative and a consultation perspective. And while consultation is a matter that begs a bit of complexity, I can't help but look at the record with respect to my colleague, Senator Boisvenu, and his recollection of the evidence and testimony that came before the committee. When I look at an amendment, when I think about consultation, yes, there are provisions like non-derogation clauses, things of that nature. But as mentioned previously, litigation, I believe Senator Quinn mentioned it as well. When it involves litigation, when it involves the advancement and protection and preservation of Indigenous rights, it is a costly exercise borne upon First Nations groups and organizations, and it's largely an access to justice issue. Although one can look and hope that the duties with respect and the obligations of the Crown with respect to consulting with Indigenous peoples takes place, it's still, an exercise that has a bit of, let's just say, subject to debate and criticism. When I look at this provision, it's a positive inclusion within an actual statute. It's there. It provides guidance, like other pieces of legislation, to government to take into account the rights of Indigenous people and to consult on matters that are integral to who they are as a people. We're talking about subsistence rights here, and as my colleague, Senator Patterson, has mentioned, these are very significant rights that relate to livelihood. So I'm in agreement with this amendment. I think it provides a prescriptive way upon which consultations can take place, and it will provide guidance for lawmakers as well. Thank you very much.
So I have Senator Lankin has a question, and then Senator Osler, and I was wondering if Senator Prosper would accept the question. Yes. Senator Lankin.
Thank you very much, Madam Chair. I was going to defer to Senator Osler to go first because I have risen on this general issue. Senator Prosper, I appreciate your intervention and hearing your voice on behalf of Indigenous peoples and the disappointment with the way in which governments have not lived up to their obligation to consult. You as a lawyer, I'm not a lawyer, I'm a trade union negotiator, among other things over the years, but contract language and requirements, and as a former Ontario legislator, I've been involved in drafting, writing, amending legislation. My problem with your argument is that saying it 2, 3, 10, 20 times in a piece of legislation doesn't compel any government to live up to their obligations. We have seen this over the years. Section 35 has been around a long time. The obligations are there. In this case, they even wrote that into the bill already. This is a duplication, and it's a narrower amendment than what the Section 35 rights are. And I would think you would agree that courts look to all of the provisions and how they work together and what was the intent of the legislature in doing this, and it can create problems. Please tell me why saying it 2, 3, or 4 times in one bill is going to help us correct this and avoid a government abrogating the responsibility, and it will end up in court anyways, whether or not this amendment is put in place.
Senator Prosper.
Thank you for your question, which is much appreciated. I don't think, certainly it's within the realm of the courts to determine whether an added provision like this will somewhat narrow what exists within, as a general rule of law, with respect to the jurisprudence of constitutional law as it relates to Section 35. I can only think, and I don't think this provision would override that. Ultimately, the Constitution is the Constitution. And should this matter come before a court of law, the Constitution always trumps, it has paramountcy over federal statute. But if anything, this provision here could be read or provide further guidance to the courts with respect to that adjudication of the matter. So I think it can provide clarity, and if it conflicts, I'm sure a court of competent jurisdiction will say so. Thank you.
Senator Osler, you have a
Thank you,
question?
Madam Speaker. Senator Prosper, in your legal opinion, can you foresee any unintended consequences from this amendment?
Senator Prosper.
Thank you for the question, Senator Osler. When I read this particular amendment, it's quite prescriptive in terms of what the obligation is upon government. It doesn't leave it to jurisprudence. I mean, it can be subject to litigation and court proceedings, but if anything, it provides guidance with respect to what is to be undertaken with respect to these rights, which are so critical for Indigenous peoples. Thank you.
Senator Patterson Nunavut, do you have a question?
Yes, please.
Will Senator Prosper take another question?
Yes.
Senator Patterson Nunavut.
Provision in the bill that everybody is saying takes care of this issue of consultation with Aboriginal peoples is only the standard non-derogation clause. Don't worry about it clause. Section 72(1)(1). The provisions enacted by this Act are to be construed as upholding the rights of Indigenous peoples recognized and affirmed by Section 35 of the Constitution Act 1982 and not as abrogating or derogating from them. Does that give you any comfort that this non-derogation clause, which is widely seen in government bills, will force the minister to consult on regulations which impact Indigenous people?
Senator Prosper.
Thank you for the question, Senator Patterson. You might recall a bit of dialogue and discussion on a separate bill with respect to S13, an act to amend the Interpretation Act and related acts, which seeks to get that within the Federal Interpretation Act and take it from existing acts and make that point irrelevant or unnecessary. But the fact of the matter is, while useful having a non-derogation clause within an act, it's not necessarily followed followed or the direction isn't sought in accordance to that non-derogation. One can think, why have a non-derogation to begin with if we're talking about a constitutional right? We know those rights are the supreme law of this land and therefore should take precedence over subordinate legislation, whether federal or provincial. But I don't draw any comfort in a non-derogation clause. Just look at the bulk of litigation and jurisprudence with respect to Section 35. It still exists, and and I don't see that being a determinative feature to force public officials to really consult and deal with the nature of Indigenous rights on in a legal fashion as it should be.
Senator Ringuette.
Would you take another question, Senator Brown?
Yes.
Thank you. I've been listening to this debate and the many confirmation of Section 35. But what has particularly taken my attention is Senator LaBoucane-Benson, when she said that in this bill there is confirmation that the regulation will be tabled in both houses of Parliament. I've been in this place for 21 years. I think today. Not true. But I have never seen in a bill an imposition on the government to table the regulation following the legislation to both houses. So I view that as an additional assurance in regards to your concern. What do you think about that?
Senator Prosper.
I appreciate your comment and congratulations.
or sympathy.
I certainly get your point, Senator, with respect to seeing a provision like this being tabled within both houses, and I applaud that recognition. The unique feature about this amendment, I believe it goes beyond that, and it goes to the core of consulting with Indigenous peoples. And I think that's an incredible provision to have on such a critical piece of legislation. So it gets to the core of consulting with Indigenous people, and it provides a positive legal obligation within a statute to do so on such critical matters as regulations.
Senator Boisvenu, vous avez une question?
Senator Boisvenu, do you have a question? Senator Prosper.
Yes.
Senator Boisvenu.
Merci beaucoup, Madame la Présidente.
Thank you very much, Madam Speaker. Senator, I believe everyone will agree that it is true that once a regulation is adopted, it will be tabled in both houses. That's not the problem. The problem is, before the regulations are written, the Indigenous peoples have to be consulted on the content of the regulations, because after that, after the tabling in both houses, it's too late for that. Do you agree?
Prosper.
Thank you for your comments, Senator Boisvenu. I tend to agree with what you just said there, that as mentioned previously, and I think, I really want to get to the core of that, is the critical thing or critical matter, I believe, within this amendment is actual discussions, preliminary discussions before actual development of the regulations. I mean, it gets to the core and substance of the regulation itself, ensuring that appropriate consultations take place before it goes to both houses. So I think that's the critical feature here. Thank you very much.
Are senators ready for the question? Okay, I'm sorry. Senator Prosper, will you take another question? I have Senator Boyer and then Senator Patterson if there's more time. Senator Boyer.
Thank you. Senator Prosper, I'm wondering if you see any issues with the definitions in this section, and especially the Indigenous organization, meaning an Indigenous identity that represents the interests of an Indigenous group. I'm wondering if there's anything with these definitions that could be perceived as ambiguous in any way.
Senator Prosper.
My apologies. I'm just looking at the bill right now. Could you just guide me to the...
I'll flip the page, Senator.
Yeah.
It's on the amendment, and it's 118.1, bracket 3, the definitions.
Under Indigenous organization?
Yes.
Indigenous governing body and Indigenous organization. Do you see anything that could be ambiguous in those definitions?
Well, there is provision within the definition that talks to an entity that's authorized to act on behalf of an Indigenous group. And there are questions with respect to that authorization and, in part, sometimes the legitimacy of Indigenous groups. Okay, granted. Those, I'm sure, are questions that could be dealt with through relevant discussions that government can undertake to ensure that the appropriate bodies are consulted. It could be part of the consultation process.
Thank you. So there are ambiguities in that section. Thank you.
Senator Prosper, you have an answer to that question?
What I'm saying is there could be inevitably ambiguities. I mean, what we're looking at is the existing landscape of Indigenous organizations. It's a necessary exercise when you undertake consultations with Indigenous organizations that you're going to have different organizations claiming certain rights and obligations to their membership.
On debate, Senator Patterson.
Thank you, Madam Speaker. I just want to bring up a few points responding to some of the statements that were made, including Senator Dean's suggestion that no government has ever consulted so extensively with Indigenous people. Look, colleagues, we've been through this movie before. The Firearms Act was amended in 1998, and at that time there was the same concern raised about Indigenous peoples having special and unique circumstances that had to be addressed. What did the government do? The government worked with, and I know particularly the Inuit, to develop the Aboriginal Peoples of Canada adaptations regulations, specifically to deal with the special circumstances of Indigenous peoples. This had to do with developing a regime for acquiring firearms acquisition certificates, recognizing there were language barriers to Inuit in acquiring firearms acquisition certificates, and developing a process where firearms acquisition certificates could be acquired orally based on traditional Inuit hunting practices of elders in communities. There's 21 regulations that were developed in 1998 to recognize the specific situation of Indigenous peoples. That's all Senator Boisvenu's amendment is proposing to do, is make sure we do the same process. And let me say, the Firearms Act of 1998 was equally controversial for Indigenous peoples. They were involved in the development of the regulations. There was a whole adaptation regime developed. It's been satisfactory for Inuit. They can get firearms acquisition certificates without having to read English, without having to submit written applications. That's just one example of the 21 provisions that were developed. Now, we're told the amendment is going to duplicate what's already in the Act. Sorry, no, that's totally misleading. The Act includes a non-derogation clause, standard non-derogation clause. That's the only reference to Section 35. And the non-derogation clause is negative. It basically says, in implementation of the Act, you can't override Section 35 rights in the implementation of the bill. This clause is about not acting against Indigenous rights. So if the government does something, there is a remedy. This amendment will lead to a proactive process to prevent that from happening. The Inuit were happily and meaningfully involved in developing the adaptation regulations. There's been no concerns about the Firearms Act of 1998, and there will be no concerns if they're meaningfully involved in implementing this bill. And by the way, I know the committee heard evidence from witnesses who said, you know what, we need semi-automatic weapons in Nunavut, because when a polar bear is coming for you and coming into your tent, you may need more than one shot in rapid fire to save the lives of your family and your children. So there is a genuine need to have the regulations adapted to Inuit in Nunavut. And so I feel very strongly that this amendment should be carefully considered by the Chamber. And I want to just say as well, Madam Speaker, what I said in my question to Senator Yussuff. The government didn't even bother to consult with the Inuit in development of this legislation. They are hunters. They live, they survive, they feed their families by hunting. These are not sports hunters. These are people who are like farmers. They harvest on the land using firearms. They know about firearms like no one else does. And they contributed to an adaptive regime in 1998. They should be allowed to contribute to an adaptation regime in 2023. This amendment will do that. And Senator Yussuff has told us, I hope, he said, it is my hope that rights will be respected. Well, let's guarantee it. by ensuring that the consultation that did not take place in the development of this bill will happen in the development of the regulations. And I'm sorry, regulations are published and gazetted. We all know the process. That's an after-the-fact process. This is proactive. It will ensure that the regulations are not responded to after the fact and do not have to invoke the non-derogation clause or do not have to result in litigation, but rather are done proactively, as happened in 1998. I give credit to the government in 1998 for consulting with the Inuit and Indigenous organizations in the adaptive firearms regulations. Let's do it with this bill. It's a simple, reasonable request. Now, I know there's a mantra of no amendments. That was the rule in the committee, which I understand is probably the government's desire. But this is a reasonable amendment. No one will oppose this amendment. Let's do it right, do it properly, and make sure that the consultations that took place in '98 also take place in 2023 in the all-important development of the details, the regulations. Please support the amendment, honourable colleagues. Thank you.
I have three senators rising on a question. Senator Gold, and then Senator Arnot, and then Senator on debate. I'm sorry. Senator Gold.
It's multi-party. As a lawyer, Senator Patterson, as you are, and as a legislator, as we all are, is it not the case that Section 35 in the Constitution, even if it were not in this bill, imposes an obligation on all levels of government, including government, on us as parliamentarians, but on the government, the executive branch, to respect all the terms of the Constitution? Is that not correct?
Senator Patterson Nunavut.
Yes.
Supplementary, Senator Gold.
Is it not the case, therefore, is it not the case that Section 35 in the Constitution imposes a positive obligation on all levels of government, including the parliamentarians, in our actions to ensure the respect for the rights that are guaranteed, in this case, to Indigenous peoples under Section 35? A positive obligation, whether it's in the legislation or not.
Senator Patterson Nunavut.
Well, sure, there's a positive obligation, but that's no guarantee that it's going to happen. And it didn't happen in the development of the bill. Natan Obed said, we weren't consulted in the development of this bill. So that gives me good reason to say, let's make sure the Inuit are involved in the development of regulations proactively, positively, so that when the regulations are tabled in the Gazette and in both houses of Parliament, the Inuit will be saying, yes, we were heard, we were given the respective consultations, and things are okay by us, just as was done in 1998, when they were actively, collaboratively involved in developing the firearms adaptation regulations. This is just as important in this bill.
Senator Gold, I have two other. So I'm going to go back. I'm going to go to Senator Patterson, Ontario, and then Senator Dalphond, come back to you. Senator Patterson, Ontario.
Senator Patterson Nunavut, would you take another question, please?
Yes.
Thank you. So I'm not a lawyer, and I've heard a lot of things in the debate on the amendment. And I'm hearing a couple of things. I'm hearing about proactivity, which is in the consultation and development of legislation, versus discussions around Section 35 of the Charter, the Constitution Act, which talks about implementation. So, Senator Patterson, could you clarify for this non-lawyer, does this clause allow us to close the gap between what seems to be on implementation versus trying to do it in the development phase? Thanks.
Senator Patterson Nunavut.
Thank you for the question. You know, this government, and I love to hear the phrase, you know, they say nothing about us without us. And that, by the way, is essentially the provisions in the United Nations Declaration on the Rights of Indigenous People, which this government has also adopted, is that there will be a collaborative approach to developing legislation, especially legislation that impacts Indigenous peoples, like surely firearms legislation does for people who make their living and feed their families by hunting. So I believe that what we are seeing here is an opportunity to prevent problems from happening, as has happened in the development of this bill, as is illustrated in the need for this amendment. They weren't consulted in the development of this bill. Let's make sure they're consulted in the development of the regulations. It's proactive, it's positive. It's not negative. You're not allowed to do anything that will impair our rights. This process proposed by Senator Boisvenu, which I think includes a broad definition of Indigenous groups, I have to respectfully disagree with Senator Boyer. This will ensure that the regulations, just as they were done in 1998, respect and reflect the unique circumstances and needs, as is outlined in the amendment by Senator Boisvenu, of Indigenous groups, communities, and peoples in a proactive, positive way. Not after the fact, well, we overlooked that and we'll have to go to court, hire lawyers, sue to get our rights recognized. Let's do it right in the development of the regulations so we don't have these ongoing problems and solving issues by having white-haired judges determine Indigenous rights. Let's do it with the Indigenous people as proposed in this amendment. Thank you.
Senator Dalphond.
Senator Dalphond. Would Senator Patterson take another question?
Yes.
Senator Dalphond.
Senator Dalphond. Thank you, Senator Patterson. This may be my last chance to ask you a question. Rest assured that I appreciate the opportunity. Senator Patterson?
I'm also a lawyer by training and a judge. And I think the basic principles have to be remember here, but for non-lawyers. First, in legal order, there is the Constitution. The Constitution prevails over the laws and regulations. If a law or regulation is contrary to the Constitution, it's null and void, and the courts will strike it down. So the first point. The second point, so the second point is we just amended the Interpretation Act to incorporate in it a provision that says all laws and regulations and statutory instruments from the federal government must comply with Section 35. Don't you believe that all these things together are enough? Maybe we have the suspender and the belt, and now you're proposing what do we need more? Is there a point where the system makes sense while repeating things all over the map?
Senator Patterson.
Senator Dalphond, I'm terribly alarmed to hear that this might be your last chance to ask a question. I hope you're not considering resigning from the Senate. We need you. We need you in the Legal and Constitutional Affairs Committee.
Senator Patterson, you have the floor.
Look, you've pointed out, as Senator Yussuff has pointed out, there's a remedy in the courts if Indigenous rights are violated under Section 35. I'm saying, how do we guarantee before the fact, before the rights are violated, rather than trying to fix it up after the fact? How do we guarantee that this doesn't happen in the development of regulations? It's by guaranteeing consultation. A broad non-derogation clause doesn't guarantee what Senator Boisvenu has laid out, that there's a proactive, before-the-fact obligation on the minister. We don't, as much as you're a former judge, and I respect that, and the courts will strike laws down, let's not make the Indigenous peoples go through that. Let's involve them to make sure the regulations respect their rights. That's all I'm saying, honourable senators.
Thank you. Having conceded, Senator, having agreed with me, I'm sorry. Forgive me for my tone in this question. I do apologize. There is a positive obligation to consult that flows from the Constitution. That is also embedded in this legislation. And therefore, no matter how many times we put it in the legislation, it remains the case that there is a positive duty recognized in law, both in the Constitution and in this bill already, for Indigenous peoples to be consulted in the making of regulations. And you've agreed with that. My question is as follows.
Senator Gold, I'm sorry, but time has expired. On debate has expired. Senator Patterson, would you accept, would you ask for more time to answer the question?
No.
I hear a no. So on debate, Senator Arnot.
Thank you, Speaker. I support the amendment that Senator Boisvenu has put forward here. I asked the question, what is one of the reasons that we're here? We're here to protect minorities. Look at the track record. The only reason we're having this discussion is that the government failed to consult with Indigenous people properly, even though they've been required to do so since 1982. So 41 years later, they didn't do it in this case. To me, that is a reflection of an ongoing attitude. I could argue right now that there's been a breach of the fiduciary duty under Section 35 because of what the government has already done. Moreover, it's a breach of Indigenous rights, which are constitutional rights. As well, a breach of the honor of the Crown, that high standard. That's already happened. We should not be countenancing this kind of action by the government vis-a-vis Indigenous people in this country. Now's the time to stop it. We can do that. It's been an interesting explanation from our friend Senator Yussuff. It's an admission by the minister that he failed, he fumbled the ball, he made a mistake, and he's going to try to clear it up, and that's good. I'm not suggesting that's otherwise. However, the best prediction of the actions in the future are the actions in the past, and it's a bad story, dating some 41 years, where Indigenous people are required to hire a lawyer, go to court, spend millions of dollars, 7 years, and litigate a case. Litigation's an admission of failure. Don't put people into the place where they have to litigate. This should be a problem-solving exercise. The way to do that, in my opinion, is to support Senator Boisvenu's amendment. What's the downside? What's the downside? There's no real downside because, as Senator Prosper pointed out, and Senator Gold, the Constitution is the highest order of the land. We have to follow that, and the courts will to do that. I want to just mention, with respect to Senator,
Boyer.
Yeah, Senator Boyer, my friend Senator Boyer. Senator Boyer, these definitions were in the C-29. There are new definitions that have fit by the government Canada. So I'll just say that. So with that being said, I say that there's been a failure. There's been an attempt to cure it. Can we trust the government? I hope we can, but let's not do that. Let's give it a backup, and Senator Boisvenu's amendment will do that backup, in my opinion. I think it's best to err on the side of protecting minorities, and we have a chance to do so here now. One of the things that I reflect on is Senator Prosper's actions in these amendments in the Interpretation Act. It failed. But really what's at heart of this is that the Government of Canada should have, as a matter of policy, in any policy they create, an analysis of the treaty rights, the Indigenous rights of Indigenous people, and an answer to that question. How does this affect Indigenous people? How does it affect the treaty rights? That would be a much better way. Just to put it into an Interpretation Act and make an assumption that it's all going to work out is wrong. That's why we have litigation. So I support Senator Boisvenu's amendment and encourage my colleagues here to think very carefully about that. If you want to really think about it, look at it from the eyes of an Indigenous person being told, we will promise you, it's going to be better next year. You know, if you're an Indigenous person, you know, I'm sure you'd answer that question by thinking, not on your life, I don't accept it anymore. And I say that's what we should be telling the federal government right now when we have the opportunity. Thank you.
I have Senator Duncan, Senator Lankin, and Senator Cardozo all on question. Senator Duncan.
Thank you. Senator Arnot, will you take a question? What's troubled me about the amendment before us, and it goes to the discussion of the definitions, and what has struck me throughout this debate is that there are as many definitions of what constitutes consultation as there are First Nations Indigenous groups across this country. Consultation means different things to different people, and there's no consultation protocol that exists in the Government of Canada. And that's part of the problem. We have the constitutionally protected rights. Senator Dalphond has spoken to that. I think this amendment, from what I've heard, is redundant if we don't clarify exactly what it's supposed to do, which would be a definition of consultation. And I think that for that reason, I'm struggling with it. I appreciate the passion that you brought forward, but I also know when I first stood in the House, in the Yukon Legislative Assembly, I was asked, well, have you followed the consultation protocol duly negotiated with First Nations? And that's why I can't support this amendment, is because what's consultation? So do you have a definition?
Senator Arnot.
I don't. Pardon?
Senator Arnot,
yeah,
yes.
It's been litigated, and it's, you know, even that's been litigated. But I would say, yes, you're right. It would be good if the federal government had a protocol that was understood and that it was torn to by Indigenous people, but they don't. Similarly, they don't have a policy where they do an analysis on every piece of legislation coming out of the from the House of Commons or the federal government implementing policy, to make sure that there is an analysis of whether it breaches Indigenous rights, treaty rights, the fiduciary duty.
You have a supplementary, Senator Duncan?
What you've said repeatedly is talked about policy. And this is the legislation. So to me, the administrative law is we've got the Constitution, now we need the policy. This is where the rubber's going to hit the road. So we urge the government to have a consultation protocol in place that applies throughout government. We don't write it in legislation.
Senator Arnot.
Senator Boisvenu is trying to do is trying to help solve a problem which the government created by not doing the consultation correctly in the first place. And I believe that there's no downside to implementing this particular amendment, in my opinion.
Senator Lankin.
Thank you. Thank you very much, Senator Arnott, and I appreciate the knowledge you bring to this and your past experience, both legal and in terms of working with and supporting First Nations in your province and beyond. First of all, and we can all have different opinions, I have an opinion that there is a potential downside. But putting that aside, and by the way, I agree with Senator Patterson on a lot of what he said that has not been done to include Inuit people. I have no complaint with what he has said. What I want to ask you, and ask the others who have made this point, is what makes you think putting this amendment in is going to be preventive in any way? If a government is not going to follow the Constitution, the Interpretation Act, their own legislation, a minister's letter that says, I messed up and we're fixing it now, what means to you, how does this amendment ensure that the government will do it and that First Nations people won't end up having to litigate it anyways? This does not preclude further litigation if they don't live up to their already multiply stated obligations. And this bill is important, and I know that there are tons of amendments coming. Think about what we're doing in one place or the other. Where are we attempting to make the situation better by repeating something that is already ensured across laws. It does nothing to address the basic concerns that I agree with that Senator Patterson has put forward.
Senator Arnot.
Well, one way to look at it, let's say you're a judge in the Supreme Court of Canada and you're looking at this at some point in the future, and you see this in the legislation, and it says, well, the legislature spoke. You're supposed to do that. Not only that, it's the Constitution as well. It enhances the argument, in my opinion. It would, and I believe that that's the right point to do.
Yeah.
It's excellent. It gives
litigation.
Yeah. Well, that's my opinion.
Senator Cardozo. Senator Cardozo, you have a question?
I do. Thank you. Thank you, Madam Chair. I agree. I agree very much with the intent of what you've said, Senator Arnott. I agree very much with Senator Boisvenu's amendment. But I have, excuse me, I think I have the floor. Thank you. I'm thinking of some of the voices we heard. When you say, what do we have to lose? What is the downside? My answer is Bill C-21. I want to just say a couple of things. I look at Polly Sessouvien, who said, we recommend that the Senate pass the bill as is so that it can be implemented as quickly as possible. We support Bill C-21 because of some of the very strong measures to better protect victims of intimate violence, as well as the public safety potential prohibiting of the freeze on handgun purchases, in addition to other measures. We can try to make every bill perfect, but we live in a real world. The chaos in the other place is enormous. Let's not pretend it's not happening. The chances of getting C-21 passed by sending it back to the House, are you prepared to give that up to ensure your amendment, which Senator Lankin just outlined, is ensured in very many places, and adding it here wouldn't ensure it any further?
Senator Arnott.
In my view.
Yeah, well, I'd like to answer that. You're talking about public safety. I don't think there's any hunter, trapper, First Nations person that I've talked to that would say that they're not in favor of ensuring public safety. I see that as a completely different issue. This is about the rights of Indigenous people, and I'll speak to that later, perhaps on the third reading of this bill. But I don't see it as being, I understand the passion. I understand the reason that Canadians need to feel protected. You know, there's a tsunami of handguns coming across the border. That's separate and apart from this issue. This is about minority rights and protection of minority rights, protection of Indigenous people. It's about reconciliation. It's all wrapped up in that, and that's the way I see it. It's that frame. Thank you.
I see that, but I think in a debate like this, we're never just dealing with one issue. We're dealing with a lot of different issues. I would say the issue we raised has been protected quite well, as Senator Lankin has, in terms of Indigenous consultation. I would just go back to the Danforth Families for Safer Communities said it needs to be supported by the Senate without delay. Every level of government needs to be involved. However, our position is that Bill C-21 is a strong contribution to the federal level of government and needs to be supported by the Senate without undue delay. So I leave that with you, sir.
Senator Arnott.
That's the answer. We didn't do the consultation. It was too difficult. It was too time-consuming. It's too complicated. You know, that's the wrong answer. We can't.
Senator Arnott has the floor. Are you through with the answer?
I'm just saying that those are the explanations we got, and they're not sufficient. We need to make sure that Indigenous rights are protected, and this is what I'm proposing. I believe that's what my friend Senator Boisvenu is proposing.
Senator Plett, you have a question? Senator Plett?
Very briefly, Senator Arnott, thank you very much. Senator Cardozo very clearly indicated that it is not our job to fix legislation. I'm surprised on one bill they want to fix it, and on another bill he's saying we should not fix legislation, which Senator Boisvenu is trying to do and you're supporting. He further indicated that this bill was going to die because the other place is in a bit of a disarray now, and they wouldn't be able to get this bill back to us. Senator Arnott, just a question. Have you heard anything about prorogation or an election coming up that would prevent the government from dealing with this at the end of January or the beginning of February if they're going home?
I think they are ready.
Senator Arnot.
Nothing I can rely on.
Senator McCallum, you have a question?
Yes, I do. Thank you, Madam Chair. I wanted to go back to the suggestion about consultation and defining it. And when we look at consultation, it's defined by the groups that they go and consult with. That group defines what it means to them. And to have a pan-Canadian approach hasn't worked, and it will never work. And we live with the reality that existing legislation, there's very little to no consultation that does go on. And First Nations are continuously left to struggle with the legislation that we pass here. C-91, C-92. I was talking to the AFN about that today. And there's limited time resources. So I think this...
Senator McCallum. I'm sorry, Senator McCallum. Time for debate has expired. Are you asking for leave to answer the question? Senator Arnott? I hear a no. Sorry. Senator Gold on debate.
Colleagues, the importance of this amendment and the importance of this bill cannot be overstated. And the passion with which all of the debate has taken place, and it certainly affected me in my questioning, is also palpable, real, authentic, and welcome. I'm rising today to speak very briefly, because I do want to get to the question, and I hope you will allow us to do that, to express the government's position, and I'm appealing to you as legislators. Legislators, of course, with convictions, passions, constituencies, beliefs, frustrations, and memories. But I'm appealing to you as legislators about what it is and how laws are actually interpreted by governments and by courts. There is a duty to consult on legislation and regulations that flows proactively and positively from the operation of the Constitution, whether it's in any legislation or not, that is independent of a non-derogation clause. There is a positive obligation to consult on the regulations that also, I believe, is implicit in the non-derogation clause that will be part of every legislation, as was outlined in an earlier intervention. It has been said that if there is if no consultation or inadequate consultation in the regulatory process, absent this amendment, well then Indigenous rights holders and groups will have to go to court to seek a remedy. It was implied, and I think indeed stated, but this amendment will change that. But that, honored colleagues, to the lawyers and non-lawyers, is nonsense. Nonsense, as Jeremy Bentham would have said, on stilts. And I say that with no disrespect, but it misunderstands exactly how the laws operate. Because there could be the most specific positive obligation in this amendment on top of the other obligations that I've already outlined. But if there is a breach, you still have to go to court. There is no avoiding litigation when there is a breach of a positive constitutional and legal obligation. So it is not true that this amendment solves that problem. It's a real problem. First Nations, Indigenous groups have had to spend far too much money and more importantly, far too much time, sometimes generations, to get their rights recognized. And the government of Canada, whether it's this government or previous government or governments before that, have been dragged by the courts into recognizing and acknowledging Indigenous rights. Dragged. And thank goodness that Section 35 in the Constitution is open-ended enough so that our courts still have the ability to learn from Indigenous voices and to articulate in the myriad of cases that have not yet been resolved, either through negotiation or litigation, what the true contours and shapes of Indigenous rights are. We don't know. Our generation is the first to really confront the extent to which rights are being held in this country. Lands were not surrendered. Treaties were dishonored. Our children and grandchildren will live in an even more expansive, in a world with much more expansive rights understandings, and it will be the courts, to be frank, not governments, who will be leading the way. So this amendment does not solve the real problem you identified, but there is a problem with this amendment. And again, if I speak passionately, I'm speaking passionately as a legislator and as a constitutional law professor, rusty, though maybe the rust is coming off a little bit. It's not to, but I'm trying to speak, I'm trying to offer you an analysis of how legislation actually works in the lawmaking process. And there are problems with this amendment. And the first one flows from comments that Senator Dupuis made, and that flow from what I just said. Section 35, if our Constitution is a living tree, right, harkening back to the Persons case that we celebrate every time we leave this building, what that means is that the contour of the rights, whether they're Section 35 rights or equality rights or any other rights, are able to evolve with time. Not because of the political whims of the day, not because of the passions of the day, but because of the evolving understanding that we have as citizens of what our rights and obligations to each other entail. This legislation, this amendment, as Senator Dupuis, has one problem, and this is downside number one, Senator Arnot, to your point, because I agree with Senator Lankin in this respect. Or if it was not Senator Lankin, then some other senator. We are all equal as senators, and your interventions are all equal of my respect. One downside is that this has the potential for narrowing the interpretation of the evolving, not yet fully circumscribed rights, duty to consult, nature of consultation, the meaning of consultation to the groups that is evolving with time. And with respect, Senator Prosper, I think that is a problem, though it is true, of course, that the Constitution trumps all. It is also true that the standard principle of legislative interpretation, we heard it recently in connection with another bill, that we are supposed to actually have meant what we say, and therefore there is a presumption that we have to sort of put all the words together, and if we put a more narrow phrase, maybe that qualifies the broader one, or maybe it doesn't. We are inviting litigation all the way up to the Supreme Court on this narrow issue that might have nothing actually to do with whether there was adequate consultation or not. So if we're trying to avoid legislation and the cost and human cost of people having to wait years, generations for their rights to be vindicated, this is not part of the solution. This is a potential problem. I can't predict the future. That's one downside. Downside two was identified by Senator Boyer. And it flows from the nature of this amendment that is coming at third reading. It's totally legitimate to introduce amendments at third reading. That's not my point. But when an amendment is introduced at third reading, it has not been studied. It hasn't been vetted. We haven't asked officials what it means. We don't have legal opinions as to whether or not the ambiguity is or is not a problem, whether it will be solved in the consultation process or not, or when one group that wasn't consulted claims it should have been, but it's not clear whether they are involved. That becomes a litigation matter. There are some downsides with the narrowness of the drafting, the ambiguity that that appears to be there, and the fact that we didn't have a chance to study it the way this bill was studied. In the other place, extensively, and in this place, extensively. There is a final downside, and that is simply that this bill is being looked upon by survivors and by communities across the country who have asked us to pass it with dispatch and without amendment. We've studied this properly. We've studied it seriously. I think as legislators, we've done our job. But more importantly, however well-intentioned this provision is, and however passionate you feel, it'll feel good to pass this. It'll feel good to pass it. I understand the feeling. But it's not the right thing to do as legislators. It's not the right thing to do. It's an unnecessary, potentially complicating amendment that does not solve the problem that, with respect, its proponents, in the best faith we assume, have argued for. So I urge you to acknowledge your feelings, but let's do our job as legislators. Our job as legislators, in my opinion, is to vote against this. Thank you very much.
Are senators ready for the question? All those in favor, please say yay. Yay. All those against, please say nay. Nay. I believe the nays have it. 2 senators rising. Do we have an agreement on a clock? 15 minutes. Honourable senators, do you give leave for a vote in 15 minutes following the clock?
5:26.
So the vote will occur at 5:26. La question est la suivante.
The question is as follows. It is moved by the Honourable Senator Boisvenu, seconded by the Honourable Senator Seidman, that Bill C-21 not now be read a third time. Dispense.
All those in favor of the motion will please rise.
The Honourable Senator Plett, l'Honourable Senator Carignan CP, the Honourable Senator Martin, l'Honourable Senator Houssakos, the Honourable Senator Arnot, the Honourable Senator Seidman, l'Honourable Senator Boisvenu, the Honourable Senator Marshall, the Honourable Senator Atulajan, the Honourable Senator Ross, the Honourable Senator Wells, the Honourable Senator O, the Honourable Senator Batters, the Honourable Senator McCollum, the Honourable Senator Patterson, Ontario, the Honourable Senator Green, the Honourable Senator Smith, the Honourable Senator Patterson, Nunavut, the Honourable Senator Wallen, the Honourable Senator Quinn, the Honourable Senator Prosper, the Honourable Senator Down, the Honourable Senator Richards.
All those opposed to the motion will please stand.
L'Honourable Sénatrice Ringuette, the Honourable Senator Gold, PC, l'Honourable Sénatrice Bellemare, the Honourable Senator Francis, The Honourable Senator Jaffer. The Honourable Senator Lankin, PC. The Honourable Senator LaBoucane-Benson. L'Honorable Sénatrice Motion. L'Honorable Sénatrice Dupuis. The Honourable Senator Cont'd. L'Honorable Senator Dalphond. The Honourable Senator Klein. L'Honorable Senator Gignac. L'Honorable Senator Cormier. The Honourable Senator Duncan. The Honourable Senator Sorensen. The Honourable Senator Osler. The Honourable Senator Bernard. The Honourable Senator White. L'Honorable Sénatrice Gerba. The Honourable Senator Cardozo. L'Honorable Senator Forêt. The Honourable Senator McAdam. The Honourable Senator Petton. The Honourable Senator Beam. The Honourable Senator Yussuff. L'Honorable Sénatrice Petitclerc. L'Honorable Sénatrice Saint-Germain. The Honourable Senator Omidvar. The Honourable Senator McPhedran. L'Honorable Sénatrice Meiji. The Honourable Senator Hartling. The Honourable Senator Wu. The Honourable Senator Lafreda. The Honourable Senator Coyle. The Honourable Senator Dasco. The Honourable Senator Kuzner. L'Honorable Senator Aucoin. The Honourable Senator Simons. The Honourable Senator Boyer. The Honourable Senator Dean. The Honourable Senator Boniface. The Honourable Senator Ravalia. The Honourable Senator Busson. The Honourable Senator Deacon, Ontario. The Honourable Senator Kingston. The Honourable Senator McNair.
All those who wish to abstain will please rise.
The Honourable Senator Pate. The Honourable Senator Moody.
Yeas pour 23, 23. Nays contre 47, 47. Abstentions, abstention, 2.
Therefore, the motion is defeated. Resuming debate on third reading. Senator Forêt.
Senator Forêt. Thank you, Madam Speaker. It's a moral duty for me to rise today in support of Bill C-21.
Marked the 34th anniversary of the feminicide at the Montreal Polytechnic, when 14 women were murdered by firearms.
In the wake of the National Day of Remembrance and Action on Violence Against Women, it's important to remember the context of Bill C-21, a bill designed to improve gun control and reduce gun violence, particularly between spouses. More specifically, C-21 calls for a freeze on the sale, purchase, transfer, and importation of handguns. Registered firearms currently in circulation may continue to be owned, used, and sold under certain conditions. A new technical definition containing the characteristics of prohibited assault-type firearms. Existing weapons on the market, however, would not be affected. The Canadian Firearms Advisory Committee will be re-established to facilitate the weapons classifications process. This classification will require all weapons to have a valid firearms reference table number before entering the Canadian market. C-21 also contains measures to prohibit ghost guns, which are unclassified firearms that are difficult to trace since they have no serial number and can be assembled from parts purchased online. Measures to combat intimate partner violence by creating red flag and yellow flag laws, and would allow firearm licenses to be withdrawn from people committing domestic violence or criminal stalking and harassment. Finally, C-21 would increase maximum sentences for firearms smuggling and trafficking from 10 to 14 years. There are several other measures included in this bill, but, in my opinion, these are the most significant. First of all, I'd like to thank the government for abandoning its ill-advised idea of giving municipalities the option of banning handguns on their territory. This proposal, which was denounced by the municipal world, would have created even more confusion, as the control provisions and monitoring provisions could have varied from one municipality to another. With over 1,100 municipalities in Quebec alone, it's easy to imagine the chaos if each had its own permit requirements, regulations, and exceptions. The government did the right thing by relinquishing, by accepting its own responsibilities. I'd now like to pick up on a few of the arguments I've heard over the past few weeks and attempt to respond to them. One argument we've heard a lot over the past few months from those opposed to C-21 is the idea that weapons used to commit crimes are mainly weapons that cross borders illegally, and that it would therefore be pointless to strengthen control measures for gun owners in Canada. On the one hand, I think that even if we have to admit that arms trafficking is a problem and we must tackle it soon and quickly, C-21 contains a number of measures to this effect. This should not prevent us from tightening controls, however, here in Canada, because many weapons held by honest Canadian citizens are, for example, stolen and used to commit crimes. For example, in December 2021, the Commissioner of the RCMP stated that 3 out of every 4 guns used to commit a crime were of Canadian origin. To quote her, according to the Tracing Centre, 73% of weapons with a known source were obtained within Canada, and 27% were smuggled or possibly smuggled from the U.S. These figures tend to confirm a number of other studies, which show that over time, and in different jurisdictions in Canada, a significant proportion of the weapons used to commit crimes are of Canadian origin, and that it would be absurd to give up control on the pretext that many weapons come from abroad. Other interesting data. According to RCMP figures, an average of 639 firearms were stolen each year from legal owners from 2001 and 2016, for a grand total of 8,952 over that period, and 90% of those were never recovered.
The conclusion is clear. The better we control handguns, the less likely they are to end up in the hands of criminals. Par ailleurs, on a entendu au cours des dernières semaines des regroupements.
For that matter, over the past weeks, we've heard from hunters groups such as the Fédération québécoise des chasseurs et pêcheurs, the Quebec Federation of Hunters and Fishermen, who expressed concern that the definition of prohibited firearm would prohibit certain weapons regularly used by many hunters, notably because of the clause prohibiting weapons originally designed with a detachable magazine with a capacity of 6 cartridges or more.
As a hunter, I believe that this provision is still too permissive. On the one hand, in the new definition of prohibited weapon, Cont'd in Bill C-21 does not prohibit any existing SO weapon. Selon Police se souvient.
According to Police se souvient, or Polytechnic remembers, there are at least 482 gun models that the government considered dangerous enough to ban last November, but none of them are affected by the latest version of Bill C-21 because the government backed down on its amendments. These models will therefore remain legal, and most of them are unrestricted. Among the 482 models that the government has abandoned are the famous, or refused to prohibit, are the famous SKS rifle, a Russian semi-automatic weapon designed for warfare from the late 1940s and imported on a massive scale since the 1980s, which fires the same bullets as the infamous AK-47. The weapon is very popular because of its low cost. Armed with steel core bullets, it is so damaging that most shooting ranges prohibit its use because it causes ricochets and perforates equipment. Do you realize how absurd this situation is? A weapon that's too damaging for practice ranges is safe enough to circulate without restriction? What's more, C-21 won't prevent new models with magazines of 6 rounds or more from coming onto the market, because manufacturers will still be able to market guns with a smaller capacity magazine, which can then be changed for a larger capacity magazine. It's important to understand that the Criminal Code prohibits the possession of a magazine holding more than 5 bullets for most long guns, on pain of criminal charges. The limit for handguns is 10 bullets. However, instead of systematically supplying smaller capacity magazines, many manufacturers of new generation weapons supply 30-round magazines, which are limited to 5 rounds thanks to a controversial mechanism. But these mechanisms can be easily circumvented, and that's what Richard Bain did in the Metropolis attack on Quebec's premier.
Has promised to tackle the problem of high-capacity magazines by criminalizing the modification of such magazines. But it would have been preferable to act upstream by trying to prohibit the import of weapons designed to accommodate these magazines. En conclusion, même si j'aurais...
In closing, although I would have liked to see more and go further, I do support C-21 because this bill reduces the number of handguns and assault weapons in circulation. It prohibits certain weapon parts. It combats ghost guns. It will help combat domestic violence. It will strengthen the Border Services Agency's ability to combat arms trafficking at border crossings. Thank you.
Senator Martin?
Move the adjournment to the debate.
Is moved by the Honourable Senator Martin, seconded by the Honourable Senator Seidman, that further debate be adjourned until the next sitting of the Senate. Is it your pleasure, Honourable Senators, to adopt the motion? Carried.
Perfect.